the indefinite strike called by some taxi association, my lord. This has disrupted the public life, free movement of the tourists, and there is a now the press release has come. Assam counterpart is going to retaliate. So at the end of the day, it's going to be a public who is going to suffer a lot, my lord. My lord, therefore, some interim order.
What are the steps with Mr. Attorney General? What steps are the government? What are the steps are the government taking to address the situation?
Sorry, my lord, I couldn't hear, my lord. What
See, this taxi strike or something where, not allowing taxis to come, or some strike is going on, is affecting the tourist traffic.
Yes.
So they're seeking permission to move an urgent PIL to.
Yes.
Well, we just want to know what is.
Yes, ma'am.
What has the state done so far? Yesterday.
Yes, my lord. Because there are discussions and negotiations with the parties, my lord. That I have also seen, my lord. Kindly have it next week. In the meantime, I will get the comprehensive instruction in the matter, my lord. These issues are better resolved through negotiations, dialogue, and.
It's on Monday.
Friday, my lord, because there's now, my lord, if there's no interim order, today's press release, if my lord have seen, that at least 2 organizations from Assam, from Guwahati, they are saying that from 18 onwards.
Maybe they're just blowing hot air now.
No, it is in the press. It is in the press.
That is already happening.
It is in the press, and yesterday.
You just take a call.
My lord.
You file it.
Yes, my lord.
And then we'll see, maybe on Friday or Monday.
My lord, I am obliged.
May please, Your Lordship. Lordship, I beg to make a mention of item number 3, Your Lordship.
Vinod Kumar Notial.
Yes, Your Lordship. Lordship, I brief
After
this
2 weeks.
2 weeks, Your Lordship.
Yes.
Much.
May please, Your Lordship, I beg to mention item number 77.
Number?
It's in single. Yes, DB.
What happened?
Single bench.
It was single bench which you has mentioned.
Oh.
Item number 1.
My apologies, Your Lordship.
It's okay. We don't make mistakes, you'll never learn like that.
Lord, the state has moved the application for modification of the lordship order dated 9th April, Lord, and placed that order on the last date of hearing.
Yes.
The lordship will kindly see the order.
Now, what do you want by this to modify? To what extent?
The Supreme Court has already directed the mechanism for clearing the forest or clearing the tree in non-forest areas, Lord. And in terms of that, Lord, Government of Meghalaya, and in pursuant to direction of the Supreme Court, Lord, has issued rules, Lord, which is 3rd September 2007. Lord, can we see the rules? My rules which are there, Lord. Rules of 3rd September 2007 in the file on last date of hearing. Rules are very clear, my lord, which lays down the mechanism for clearing the forest.
May I submit, my lord? My lord, I am praying if this matter may be taken up next week, my lord. I need to seek some instruction in this matter, my lord.
Because, my lord, this is between, there was no prayer.
I think better if one thing, Mr. Archival General, since Justice Dendo was part of the bench, so I think it would be better if this matter, he is there also. At least so he can,
Yes.
he can consult, yes.
Yes,
Yes. What do you want?
Next week, my lord.
See, from what I understand, I've gone through the thing is that now this court has issued some directions. So these directions, they have sort of supplanted the rules that are already in place. Because you now forbidden to cut in one tree without permission being literally obtained from the court. And with the committee formed by the court and all. So there has to be some via media, because the development projects are going on where environmental clearance have been got, have been received. So what happens with project? And out here, I think they've outlined the project also, which will be, adversely affected. But if we have to go through this other route whereby, the rules are already in place.
My lord.
So then you just be alive to that. Have you served them a copy?
My lord, we have received the copy.
Yes. Then we list it on Monday. This on Monday before myself and Justice W. Dingdo. Yes. This is matter. Monday with the matter and just
Daily list item number 1.
Your Lordship, in these matters, I'll be filing my affidavit in the during course of the day. During course of the day.
During course of the day.
Already I submitted.
The states were also supposed to, Lordship.
Lordship, for the state entering for 2 weeks time, my lord.
Why?
We are waiting for the response by the central government, and thereafter we will be taking our call.
Proceed. Yes.
Central government is a necessary party in this matter.
Yes.
Central government is the authority.
He's filing. Have you received a copy of the affidavit?
Lordship, we have received the copy of the affidavit filed by the Union, Lordship.
Mr. R. Devnath submits that the affidavit on behalf of the respondents number 6 and 7 will be filed in the course of the day. Stop. Mr. S. Next paragraph. Mr. S. N. Gupta, learned. You are senior.
So I am giving the copy, Your Lordship.
On behalf of respondents number
1 to 5.
1 to 5.
So, Your Lordship, I am giving the copy.
For further 2 weeks time to file the affidavit. Accordingly, prayer is allowed. Just up to 2 weeks for the order.
Item number 2.
Your Lordship, this is the PI regarding Your Lordship.
Yes.
This is the PI regarding the Aadhaar card, where the government is insisting that for all the scheme and other for anything for government scheme that Aadhaar card is mandatory. Whereas Your Lordship is very clear that there are a lot of judgment where the Supreme Court has already passed an order that Aadhaar card is not mandatory. There is judgment. I have even reflected.
Now, one thing, Mr. Sama, okay, we know about the right to privacy, okay, and whether Aadhaar card is necessary or not. That is one part. Now, talk about convenience and facilitation. Now, this is our view only. Now, Aadhaar card serves as what? What's the Aadhaar card?
Aadhaar card is just one of the document.
What is the nomenclature used for Aadhaar card? They say what? UI1.
Yes.
Unique identification.
Yes.
Correct.
Yes.
So the things that why? Because it facilitates government schemes to work better, so that the money goes directly into the accounts of the people who are availing the schemes without intermediaries, whereby maybe the money might be diverted. So Aadhaar card is one of the purposes is for that, and for it's a all-in-one identity card. So now your prayer is for that you don't use Aadhaar card at all.
Your Lordship, it should not at all. My prayer is, Lordship, only that.
It's compulsory, but you look at the convenience and look at the practicality.
Lordship, I humbly pray, Lordship, this on the basis of the order dated 2107. I think this PI can be disposed of this because I think this already served the purpose.
You think? But we might not think that.
Because Lordship, my contention is that this should not be make it mandatory in all. I'm not saying that it should be completely stopped, Lordship. There is a the order has, in view of that order it can be disposed of.
May I place this order, my lord? This order requires some modification. 21st July 2025 order, my lord. Kindly see this order, my lord.
Yes.
Now, it says this public interest PI is bound to have all India ramification. Relying on 2 judgments of Supreme Court in case Puttaswamy versus Union of India and another on 2019 1 SSC 1, London Council of Petitioner contended that under Section 7 of the Aadhaar Targeted Delivery of Financial and Subsidies, Benefits and Services Act 2016, the state government had issued a notification dated 31st October 2023 insisting on a child desirous of availing benefits of free compensation for matric scholarship on SC/ST or the financial assistance of SC/ST student of the state who are not eligible for any have to purchase an Aadhaar identification number. Law laid down in this provision, the state could not insist on the requirement. Lord, this is not correct. Lord, that this part, Your Lordship will have to modify. We have made a preliminary scrutiny of the said act. It relates to Aadhaar number card for individuals residing in India getting services, benefits and subsidies met out of the Consulate Fund of India or Consulate Fund of the state. It does not use word citizen. Section 2.5 defines resident as follows. Resident means an individual who has resided in India for period or periods amounting in all to 182 days or more in 12 months immediately preceding the date of application of enrollment. Section 7 of the said act, it is provided that central or state government may, for the purpose of establishing his entity, require the individual availing of the above benefits to possess the Aadhaar number. This proviso is very important. In section 7, provided that if an Aadhaar number is not assigned to individual, the individual shall be offered alternate and viable means of identification for delivery of subsidy, benefit or service. Therefore, prima facie does not follow that non-possession of Aadhaar number disentitles the otherwise eligible individual from the above benefit. Hence, as far as notification of 31st October 23 is concerned, an interim order we direct that the state government is at full liberty to insist on production of Aadhaar number or Aadhaar card from individuals for their speedy identification. If an individual is unable to produce the Aadhaar number or card or is unwilling to obtain, Lord, this is the problem, unwilling to obtain Aadhaar registration, then he would have to provide his identity as a resident in terms of the said act from other recognized documents like PAN, voter card, passport and so on, satisfaction of state authorities. In that event, non-possession of Aadhaar card would not be disqualification. Whole issue has to be gone into details, hearing, etc. Now, kindly see section 7 of the Act. Section 7 of the Aadhaar Act. Before I take your lordship to the section 7, kindly see prayer at page 21, my lord. Prayer 21. Prayer of the requisition in page 21. Prayer is 21. Up to 4 lines as to why writ in the nature of mandamus or certiorari or any appropriate writ or direction should not be issued, directing its state respondent authorities not to compel and insist the individual citizens and public at large to mandatorily register the Aadhaar card for the purpose of receiving various government schemes and for availing any other benefits as opening of account, gas connection, linking Aadhaar for ration card or any part direction. So prayer is, my lord, that the government should not insist for registration, the citizens or individuals to apply for Aadhaar card. This is because all Aadhaar cards are linked with the bank and under the direct benefit scheme, the entire fund goes from the central government to the account of benefit scheme. And this prayer is, my lord, completely contrary to paragraph the section 7 of the Aadhaar Act, my lord. If I can place Aadhaar Act before your lordship. Aadhaar Act is Aadhaar Act, targeted delivery of financial and other subsidies, benefit of service act 2006.
Yes.
Kindly see section 7, my lord. The lordship has section 7, authentication, my lord.
Yes.
Proof of Aadhaar number necessary for receipt of certain subsidies, benefits and services. The central government, or as the case may be, state government, may for the purpose of establishing identity of individual as a condition for receipt of subsidy, benefit or services for which an expenditure is incurred, or from the receipt therefrom form part of Consulate Fund of India or Consulate Fund of State, requires that such individual undergo authentication or furnish proof of possession of Aadhaar number, or in the case of individual to whom no Aadhaar number has been assigned, such individual makes an application for enrollment, provided if the Aadhaar number is not assigned to individual shall be offered alternate and viable means of identification, delivery of subsidy, benefit of service. So section 7 says, my lord, that provided he makes an application for enrollment, and till the time, my lord, Aadhaar number is not assigned.
So we get it. What modification do you want?
Lordship, may I just submit that this section 7, this has been declared as arbitrary and violative in the art of the article 14 of the Constitution, because this in the case of Putaswamy, the Supreme Court in 2009 Volume 1, the SCC, para 1539.11, their lordship, where it has been declared as a arbitrarily. That was there. May I just read the?
Wrong, my lord.
It is their lordship.
Wrong. I'm reading the.
And another lordship, if they want to motivate, they should.
Now, who is authored by whom? That paragraph. See, that judgment, the whole book.
Yes, lordship.
Right.
Yes, lordship.
What now? Who is? Now, no. That is whose judgment is that? It's a majority judgment. That paragraph authored by whom?
This one is.
No. See where it starts.
Paragraph 510, my lord. Paragraph has all placed at one place, my lord. Paragraph 511, my lord.
This one is, I think, associate.
Judgment is given in
This is a
paragraph 511.
Justice Mukurubindi. I think this is a full bench, lordship. The content of judge.
You have to kindly see paragraph, only one paragraph, where the picture will be clear.
Pass the book to us, Mr. Sangma, just pass the book.
Judgment. See, Mr. Sangma, this judgment, you see, there is a dissenting judgment also in that judgment itself. Okay, so before you make submissions now, when you prepare the matter, you have to see which is dissenting judgment, which is a majority judgment. Okay,
Lordship.
in the judgment itself, right?
Yes, lordship.
There's a motion. Yes, Mr. Archivist General, will take time.
Yes, Lord.
Yes.
Lordship, let them file an application if they is required for modification.
Yes.
My lord, I am arguing on merit, my lord. I am arguing on very.
So what do you have to see on paragraph 511? Whether Aadhaar Act violates right to privacy and is unconstitutional on this ground. This is means that it's professional. Yes. It takes back.
If they want to modify, let them file the application for modification, because there is no application as such.
Yes.
And they have not even filed an affidavit. They have not filed any objection to the.
You don't file affidavit till
No,
date?
they have not filed. Only the Union of India have filed. State, as of state, they don't file it till now. Which means like non-affidavit filing means it's like they are accepting the how they will stand without order.
Mr. Archival General, you're not audible.
Sorry.
Yes.
Lord,
Again.
PIL itself is not maintainable. PIL
Then you
itself
file the
is not
affidavit.
maintainable.
I thought that the pleadings were complete.
Because I have
And we
no
thought,
law,
yes.
my lord. A law.
Yes, okay, you file after on points of law, you want to seek modification. Then after General, after Meghalaya response, allowed 2 weeks time to file objections.
1 week, my lord. Because
1 week on a ground of maintainability.
Most Lordship.
Any mention?
Please, Your Lordship.
Yes.
Lordship, I want to take Your Lordship your kind indulgence in the matter yesterday, Lordship, the MBBS matter. Now there's a subsequent development, Your Lordship. The counselling is fixed on 19, Your Lordship, at 9 a.m. Lordship, we have ample papers, materials to show.
You should have prepared your petition
Lordship,
in a more.
Lordship, we were of the view that the counselling will be refixed on the next date, but it's coming. It was just uploaded yesterday in the website, Your Lordship. The
My lord, I have a
notification.
serious objection to that, madam.
Sorry.
They have not substantiated their, my lord, their proper candidate.
Lordship, we have Lordship, we will try to just grant us 10 minutes time, Lordship. We'll persuade Your Lordship.
The genuine candidates, my lord.
10 minutes time?
Lordship, just to persuade Your Lordship.
No, my
Just to Lordship, there are materials.
We understand you very.
Lordship, the guidelines.
But the thing is that you see,
Lordship, the
when you
guidelines.
come, we allowed you understood yesterday, correct?
Lordship.
Yes, we should have taken enough care and caution.
Lordship, the guidelines.
See that whatever instructions received were complete.
Lordship, the guidelines which the ministry has issued, that has been also followed in other states also, Your Lordship.
How long he served in Shillong?
Lordship, he been served only for 2 months, Lordship.
Then?
No, my lord.
Lordship, that is not a criteria per se. Lordship, kindly grant us just 10 minutes. Just 10 minutes time, Lordship.
You file it, Mr. Nampur, we'll take it up on Monday.
Lordship, the matter will come up after 1 week. It will become infructuous, Lordship.
Yes.
Lordship, we are heavily relying on the office memorandum. Kindly, Lordship, I'm praying for 10 minutes time, Lordship. Just for your kind indulgence.
The tentative view is that
Lordship, will show materials from the record.
Case, no problem. Yes. You file a miscase. It's a
I have not filed a miscase, Lordship. I filed an affidavit, bring on record the subsequent development.
You have to give me a copy.
I have served a copy, Lordship.
Yes.
Today, Lordship.
Yes, today we'll take it up.
Lordship, I'm highly obliged. I'm highly obliged.
My lord, I beg to mention item number 7, my lord. On behalf of the state respondents, my lord.
7.
Actually, she.
7. In which list?
Sorry, my lord, 71. 71, my lord. My apologies. Yeah.
Yes.
My lord, Mr. Shulai is the leading counsel here, my lord. He is on leave.
You are appearing?
I'm for the state respondents, my
Mr.
lord. She's
Sama,
for the...
he's standing. No.
No, he is also here waiting for his mention, my lord.
Okay.
No objection.
2 weeks then.
Obliged.
Please, Lordship, I'd like to mention item number 80, my lord. This is for hearing list.
It will read.
This is regarding Nokma matter.
Nokma matter we can do. What is there? 81.
80. 80, my lord.
This is that. Okay, not that one.
Delay, issue of delay.
Any objection?
No objection.
Okay, 2 weeks. Yes.
Much pleasure, Lordship.
My lord, I'm beg to mention item number 72, my lord. Here, my lord, if Lordship may allow me to kindly bring one document on record, my lord.
What document?
Additional, it's a map, my lord. GPS map, my lord.
GPS map?
Yeah, it's a map, my lord. They want to bring on record a map, one document.
Lordship.
Yeah, objection.
To adjourn in, but bringing on record because they have already, pleading is already complete.
Just to bring that map, my lord.
Fine. Now,
just very much pertinent for the matter, my lord.
This is not a part of that.
If he objects, then we'll have to hear his objections. How will that map help you?
The map, my lord, it will show, my lord, that his Akang falls under different
but
area,
it's a GPS map. It's not as per the record of the
No, my lord.
It's not from the records.
It's not from the records.
It's done by whom? It's done by yours at your own initiative.
Yes.
Then we can't accept that map. It will not be reliable.
Because, my lord, that map is in consonance with the district council book, my lord.
It's just not relevant to the case.
Unless it is certified by the authorities, it's the council that yes, it is a correct.
No, but just to show, my lord, just to show the exact view, my lord.
You can just show it. Keep it in your hand. When the arguments are being done, you can just show it.
Okay, my lord.
It's not a part of the district.
But no need to file it in affidavit.
Watch.
Then it be adjourned after 2 weeks.
When?
Then after 2 weeks, my lord.
Okay, 2 weeks, yes.
Published.
Much pleasure, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 75, Your Lordship.
Yes. Who's for the petitioner? Yes, any objection?
No, Lordship.
This matter can be closed, I think.
Your Lordship, Mr. Paul is the counsel for the commission, Your Lordship, in this matter.
Should be closed in his presence. Yes. After 2 weeks.
Highly obliged.
Please, Your Lordship, I beg to mention item number 73.
Yes. Yes, yeah, for the petitioner. Yes. 2 weeks because the documents are not available. Yes.
Similar
Yeah.
prayer for item number 76, Lordship.
76, yes. That's it.
Yes, Lordship.
Make a mention for item 78, Your Lordship. Some accommodation, Your Lordship.
Number?
78, Your Lordship.
Is that account?
Lordship, freezing of account.
It's been defreezed.
Yes, no, Lordship.
That has been freezed by the order of CGM from Kerala.
No, but that's been defrozen as per last order, right?
Lordship, I have no instruction, Your
What do you
Lordship.
want section? I can find.
In another case, Your Lordship, it was defrozen.
Not this case.
Not this case, another case. This is Markintijo.
Why taking time?
Maybe
Some instruction with regard to the
Okay. Yes, 2 weeks, yes. You are the petitioner. Yes.
much less.
Please, Your Lordship, I beg to mention item number 77.
77.
Yes,
Yes.
Your Lordship,
On
kindly
behalf of
let this
petitioner.
matter come after a week.
On behalf of the petitioner.
Yes, Your Lordship.
No objection, Your Lordship.
Okay, yes, 1 week.
Much obliged.
Much obliged, Lordship.
Supplementary list, item number 1.
What is this?
Please, Lordship. Lordship, this is the second writ petition, Lordship. Lordship, the first writ petition was the petitioner, Lordship, he approached this honorable court, Lordship, for a direction to release his pending pension amount, Lordship. His pension amount was not released for non-submission of the life certificate, Lordship. So this
What
honorable.
happened when the last order what was?
Yes, Lordship. On the last, on the 28/6/2024, this honorable court, Lordship, has directed the respondent to release the pension to the petitioner, Lordship. However, Lordship, the respondent, they released the pension
But not
as
all
per
of
the
it.
6th pay commission, Lordship.
Okay, we'll issue notice. Heard MSRP someone for the petitioner issue notice. MS M. Chang, why Dr. Muzika is present, except those we have response number
125, Lordship.
125. Notice to go to remaining respondents within 3 days. Just after 3 weeks for instructions actually.
Much obliged, Lordship.
Item number 2.
May it please Your Lordship.
The matter has been settled.
Yes,
Matter has
my
been
lord,
settled.
yes.
Yes. That's our usual order. Yes, next.
Highly obliged, my lord.
Daily list, item number 1.
Lordship, in terms of the last order, Lordship, we have taken steps on respondent number 6, Lordship. I've checked from the online portal, Lordship. It says that it has been delivered, Lordship.
So you file a status report.
Lordship.
Mr. S. Chanda, Legal Counsel Petitioner, submitted as per the
online portal, Lordship.
Online portal report. There is newly implemented respondent 6 has been served. However, there is no appearance on their behalf. Counsel permitted to file an affidavit indicating service for the next day. Just after 2 weeks.
2 weeks.
Item number 2.
Lordship, in this matter, we filed our affidavit.
Who's for a petitioner?
Mr. N. Das Gupta, Your Lordship.
None appears as a petitioner. Next para submitted by MS Emmer Chang with affidavit on behalf of respondents have since been filed. Just after 2 weeks for rejoinder, if any.
Highly pledged, Your Lordship.
Item number 3.
In this batch of writ petitions, we've been directed to file an affidavit. Or we'll be filing it during the course of the day.
What affidavit? What is the matter about?
These matters, my lord, around 40 employees of the district council, their services were discontinued. The reason being that the regularization was done against the rules, and also these are not sanctioned posts. I've been
last order according to the these are total sanctions from the courts of beyond how many such further from the terms.
We'll be filing. We have to file. We'll file it during the
last paragraph. Council petition submits that the petitioners obtain some more information having a bearing. Matter, please.
The para before that. We have filed our affidavit. The para before that, my lord. In view of the contentions raised by the parties, in order to determine as to whether the petitioner was subjected to any discriminatory treatment, it becomes necessary for this court to ascertain whether the service rules of the district council was ever given effect in relation to recruitment of posts of peon. Accordingly, it is directed that the respondents shall file an additional affidavit bringing into record the details of the total sanctioned strength of the posts of peon and how many such posts are filled by holding regular selection process in terms of the provisions of the Act. The respondents are...
Yes. Ever appointed under this recruitment rules?
No, ma'am. In fact, all the employees of the district council were never appointed as per the rules. I'll frankly submit...
Whims and fancies.
As per the rules and fancies. So what the President Executive Committee has decided is that we have to take some action.
Now, file affidavit also.
We have filed our affidavit, my lord.
Additional affidavit.
Yes,
where is that? You have received copy?
Yes, but we have to file an affidavit also. My lord, during the course of the day we're going to file.
Yes, sir. Mr. TT, senior counsel on behalf of the respondent submits that
in terms of
the order dated 9/9/2025, the additional affidavit will be filed
during the course of the day.
Yes, this when?
Week.
After 2 weeks.
After a week.
Mr. W. Jaro on behalf of the petitioner submits that affidavit on behalf of petitioners has also been filed. Next paragraph, upon this matter of 2 weeks before the orders.
Admission hearing.
Is it for disposal?
Admission hearing, yes, because there's...
Admission hearing, yeah.
My lord, item number 3 to 35 and 36 is connected. 37 and 40. 3 to 35.
35 and then?
37.
And then?
Lordship, I'm appearing for item number 36.
36.
And 37 and 40.
You can give the
Yes, my lord. Stay order may be continued, your lordship.
Stay order?
It's there, lordship.
Interim orders, if any, shall continue the next day.
In item number 40, we have filed our rejoinder, lordship. Yesterday.
Just note 40 submits for rejoinder has been filed.
38.
Obliged, lordship.
38.
Wait, please, Lordship. I'm praying for some further time to file my affidavit, Lordship. Having some difficulties with getting the instructions.
No objection, Your Lordship.
Yes.
I have 5 minutes.
As prayed further, 3 weeks time is allowed to the ADC respondents to file affidavit just thereafter.
Much obliged.
39.
My lord, the lordships wanted to hear this matter on the maintainability. That is why it's listed under the admission column, my lord.
Yes.
My lord, may I start, my lord? Because
they question maintainability, they have to start and you have to answer.
Yes, let them start.
My lord, my difficulty is AG is leading this matter, and I believe he is stuck before the other court, my lord. Can we have this?
The other court in this.
My lord, I mean to say before the Supreme Court, my lord. Can we have this at the end of the board, my lord?
End of the board.
End of the board.
End of the board.
Yes.
41. 41.
Please, Lordship.
Your Lordship, I'll require 1 week's more time.
Why?
To file the affidavit. Lordship.
Last it sought how much? 2 weeks time.
That was my first appearance, Your Lordship. First appearance was that, so I was asking this court to give 1 week's time. Lord.
1 and 2.
They are filed. They are filed. I'm praying for.
Learned counsel. No objection.
No
objection. On behalf of the respondents number
3 to 10.
3 to 10. Please forward out for the 2 weeks time to file affidavit.
I am praying for some time to file a rejoinder to number 1 and 2, Lordship.
Yes, prayers allowed. Next line, Mr. SDF also submits that rejoinder will be filed to the file
Respondent 1 and 2.
In the meanwhile.
42.
Yes,
Lordship.
42 is also a similar matter, Lordship.
Similar.
This matter also, my lord, 1 and 2 we have filed, my lord.
You also appearing there? You have filed affidavit? No. Respondent's number?
Lordship, here 1 and 2 has filed the affidavit today. I mean, on the last occasion, Lordship, on 16th. And
you entered the appearance here.
3 to 9. Here is for 3 to 9.
But your names are recorded here.
3 to 9.
Or they filed the.
You filed a wakalat.
3 to 9.
Yes. Mr. Edhar is present on behalf of the respondents 3 to 9. He prays for the allowed 2 weeks time to file affidavit. Yes, what do you want?
I am praying to file a rejoinder to 1 and 2, Lordship.
Yes, Mr. Edhar to the rejoinder. What about number 10?
10 is the state, Lordship.
State, no filing.
Mr. Sincon.
Mr. SDF prays for the allowed to file a rejoinder to affidavit filed by the
Respondent 1 and 2.
Respondent 2.
Much obliged.
Obliged.
43.
Please, Your Lordship. I am informed, Lordship, they have a prayer for adjournment. I have some serious objection to it, Lordship.
Okay.
Because it was on their request that the date was fixed today. 2 witnesses have come.
You brought witnesses.
2 witnesses have come, Lordship.
I will examine them. Make arrangements.
Lordship is having some personal difficulty.
Who's had personal difficulty?
Utica, Lordship.
You're here. So the court cross examine, is that alright?
Lordship, I have no instruction on that, Your Lordship.
Then you'll have to pay cost. Are you agreeable to that?
Lordship, I already informed them yesterday, Your Lordship.
Yesterday, you from Garfield, they will already be here and yesterday.
Lordship, yes.
If you have to take, you should at least inform them at least, reasonable time. Who are the counsels appearing in the matter?
Utica, Your Lordship, by Palawi.
Who else is there?
Me and
See,
her.
this court doesn't like that witnesses come from far away and then adjourn's taken, they have to go back. You pay them 5,000 rupees each as cost for the trouble.
Lordship, I already informed them yesterday morning, Lordship.
Yesterday morning?
Yes, Your Lordship.
You pay cost because of a fixed date for adjournment. An application for adjournment on behalf of the respondent has been filed today, stating reasons of personal difficulty of the conducting counsel. What's the name?
Utica Palawi.
MS so-and-so. Mr. Pala, who is present in court, submitted that. Mr. S. Depp, on behalf of the election petitioner, submitted that where have they come from?
Lordship, the one witness has come from Bagmara and one from Clariot side, somewhere in Clariot.
Mr.
West
S.
India.
Depp submitted that the 2 witnesses.
Not within this district.
Yes, 2 witnesses who are to tender the evidence today are already in Shillong. One coming from Bagmara
Lordship,
South
Bagmara
Tara
and
Hills, the
one
other
from West Jente Hills.
East Jente Hills top. Though this court are inclined to grant adjournment, but in view of the persistent difficulty of the, this court not inclined to grant adjournment in view of the fact that the witnesses are present in court today. However, in the interest of justice and due to personal difficulty, the matter shall stand adjourned to
2 weeks, Your Lordship.
2 weeks, subject to the payment of costs to the witnesses for a sum of rupees 3,000 each. Yes.
It may be recorded, Lordship, in the next date. If they don't close the exam, it may be closed.
Over to the council. Yes. You give it to them 3,000 each for their trouble. It'll be enough, or they want some more.
So cost is not the issue. I'm only praying that in the event they don't take it out on the next day, it may be closed, Lordship. Necessary orders.
It is further observed that in the event that on the next date adjournment is sought, further orders will follow this.
Much obliged.
You pay them 6,000 rupees.
44. 44.
Yes.
But there is still the benefit of a cipher category.
Yes, we'll have another date. Dr. Mozka is not here. Yes. Yes, due to absence of the learned DSCI, this matter for 2 weeks. Yes.
Very obliged.
Yeah, some personal difficulty. Yes.
45. 45.
My lord, 45 and 46 are connected matter, and on the last date, my lord, we have produced one letter, and our submission was that another inquiry, 2-member inquiry committee has been constituted to conduct an inquiry matter with regard to Rajabala school, my lord.
Not only a communication that the committee has been constituted has been given, Lordship.
So we have given.
What is the outcome of that, Lordship? We don't
My
know.
lord, the inquiry has been concluded. We have been informed. So if the matter can, Lordship can have this matter either after 1 week, my lord, or orders are yet to be passed here, my lord.
Lordship can have.
Oh, my lord, we can dispose of this matter, directing the concerned officer to dispose of within a period of 1 week or so, my lord.
My lord, one inquiry already been completed, and my lord has passed the direction to take appropriate action in terms of the inquiry report, my lord. But
This is the second inquiry, my lord.
I am, my lord. But
Second
the
inquiry.
inquiry is necessitated. I don't know, my lord. My lord has passed a direction to take necessary action, appropriate action in terms of the inquiry submitted before this honorable court. No action has been taken. And despite of that, my lord, they passed an order, last occasion submitted before the court, to constitute a committee and to again inquiry the issue, my lord.
My lord, the first inquiry was.
Why is the first inquiry not sufficient?
My lord, the first inquiry was directed to Deputy Commissioner Office, my lord. An officer, the rank of ADC, has conducted the inquiry. So once the inquiry called, my lord, some of the suggestions and be given does not appear to be proper, and some of the parties has actually complained with regard to the.
So you have objections to the inquiry report
My
yourself?
lord, we were willing to take the action, my lord, but from some ends, my lord, the.
Which order is that, Mr. Hassan?
My lord, we have filed to an affidavit also.
2025.
We have filed an affidavit bringing into record the inquiry, the first inquiry report, my lord.
My lord, interestingly, my lord, in the second inquiry, what they have constituted the committee is the IO is the, my lord, District School Education Officer, Tura, my lord. Now, in the allegations which were come forward by the parent guardians, because the DSCO himself is in the, my lord, there is certain allegations which were against the DSCO also, my lord. Now, he become the IO in the second inquiry. Because there is, my lord, as per the allegations by the parent guardian.
Where was Shulai?
My lord, he is on leave, my lord, sanctioned leave, my lord. My lord, they have all the right to challenge the order, my lord, subsequently, because when the second inquiry was called for, my lord, none of the parties have actually objected, my lord. Now they are coming after the second inquiry report has come, we are submitting. Now they are having objection, my lord, because it was from both the end, my lord. They wanted us to file the report bring into record. There was no objection. After ultimately, my lord, this matter was to be heard again. It was, my lord, adjourned. So now, my lord, we have to go for the second inquiry. And now, once I don't know why my friend already has he seems to have the knowledge about what is the components of the inquiry, my lord. When we have just received.
No, my lord, I just bring on the record my lord, last order.
I have not bring it to record.
You see, there's a judicial order on 8/5/2025. It says that it's expected that the respondent shall take immediate steps to ensure appropriate action and terms of inquiry report as expeditiously as possible. What
True,
have
my
you
lord.
done? Now you found that that inquiry report is
Was not sufficient, my lord.
competent.
It was not sufficient, so we have to go for the second
have you taken
inquiry.
the leave of the court for the second inquiry?
My lord, we have produced, my lord, and court lordship has apparently allowed, my lord.
In fact, by
1/8,
order
my
dated
lord.
1/8/25,
1/8, my lord. Lordship may have 1/8.
That committee has been constituted and they are going to.
Now, as per in terms of the first inquiry,
Lordship may kindly have order dated 1st August, my lord. 1st August, Lordship has.
one second, let's look at the
my lord.
affidavit. That was,
1st August, my lord.
we will clear up matters very confusing. Now, 12. This is the inquiry report.
My lord, yes, we have filed on the 30th of April, my lord.
Right.
Which has been filed by the Assistant Commissioner.
Assistant Commissioner Tura, my lord. This committee was.
Dated 21/2/25, Lordship.
Now let's see a Verman's main affidavit.
My lord, we have simply brought into record the inquiry report, my lord, since the order was to bring into record, my lord. No such specific
My lord, there are
averment,
five, my lord. Please to pass necessary order or orders, my lord.
which was not, my lord.
After that, my lord, 8/5 order was passed, my lord.
Yes. So how can you?
It was examined, my lord, and there was some difficulty on the part of the department to come to a conclusion with regard to the inquiry report. And my lord, 1st August order, my lord, lordship has given us leave to take appropriate action in terms of the second inquiry, my
You
lord.
see, the court always, passes orders and assistance and on the submissions.
My
also.
lord.
If then we'll have to every submission that you make, then we'll have to look at it 3-4 times.
I see that, lordship.
Especially in the state I'm
My
talking
lord,
about.
my lord.
So if you say that 1/8 is see, no leave was taken.
Yes, my lord.
My lord may have, my
And this
lord.
court also was misled in the sense that that order 28/5 was 8/5 not mentioned at all.
My lord, we have senior counsel has time and again, my lord, submitted that we would want to pass an order. It was from the other party, my lord. They
When is
wanted.
Mr. Shulai?
Mrs. Shulai will be here on Monday, my lord.
We'll list this matter on Monday. We'll pass some orders because otherwise.
Yes, my lord. We are expecting to take appropriate action in terms of the order.
No, we will go through all the orders.
My lord.
Item number 45
on the
and
prayer of the council, learned GA, the absence of ND Shulai, the senior counsel conducting the matter on behalf of state respondents. This is matter on Monday as a fixed item.
47. 47.
Please, Lordship, as per the last order, Your Lordship, we have taken a fresh step to serve the notice to private respondent number 5, 6, 8 and 9, Your Lordship.
Have they been served now?
We have served it, but it's still awaiting, Lordship. So, Lordship, we pray that maybe liberty may be given that we may serve to justice.
Your Lordship, I am entire appearance on behalf of respondent 5, 6, 8 and 9.
Very good.
Your Lordship,
What's
I'll
your
file the
name?
wakalatnama. H no.
Yes,
I'll file the wakalatnama in the course of the day.
Let's do so. As the parents on behalf of respondents 5, 6, 8 and 9, as such service complete all respondents.
Gotcha.
You pray for my 2 weeks time for affidavit. Yes. Learned counsel prays and observe 2 weeks time to file affidavit. This is the after on so much.
Much obliged. Much obliged, Lordship.
48.
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mr. H. R. Guru, who is on sanctioned leave, Your Lordship.
Who?
R. Guru. R. Guru. So I am seeking praying for adjournment of this case today, Your Lordship.
Mr. SD wanted to prepare the
Lordship,
matter
yes.
better.
My
You
humble
prepared today.
Lordship, yes. On a simple issue, whether the, considering that the complaint was made by the person who died was a non-tribal. Complaint was made by a tribal person, whether it can be transferred or not.
It is non-tribal, it cannot go to.
When is Mr. Gurung coming?
He's 19, up to 19, he's on sanctioned leave. So next Monday or Tuesday, Your Lordship.
After 2 weeks, Lordship.
As the Army Council, as the learned GA of PP.
GA, Lordship, I think.
PP.
Transfer petition.
GA.
Is it?
It's a transfer petition, I think.
As the learned GA, Mr. Arguru said to be on leave This is matter after 1 week is
Published.
49.
My lord, steps have been taken already on respondent number 2, and it seems that it has been served through postal track via respondent number 2.
yes. Though office note indicates that service is not complete or number 2, comma Mr. S. Pandit submits that
I'll just verify from the postal.
he prays without to verify the same list after 1 week.
Much obliged. 50.
Lordship, in terms
What
of the
instructions do you have? The Pandit is appearing.
My lord, yes.
Lords, we have instructions, my lords. My learned friend is carrying the instructions in respect of the entities who have come out as successful bidders, my lords, out of the tendering process. So, lords, one RT enterprise is L1 for category 1, and for category 2 and 10 is RN medical supplier.
R1, L1 is for category 1 what? What kind of equipment? Anyway, it must be a long list. Yes, Mr. Chanda.
Yes, my lord, if I go by the letter, my lord, again, my lord, it shows that this is a single tender, my lord, which you had pointed out earlier, lordship. And
So
to that effect, in this
there are
case,
two entities that have
lordship,
been.
and it is for what? Different categories, lordship.
What
RT
categories
Enterprise
are
Seal
you bidding
L1 category and RN Medical Supplier is for L1 for category 2 to 10, lordship. Now, as per their own lordship delegation of financial rules, lordship, if there is a single tender, then lordship, it has to be re-tendered.
No, L1 is lowest. It's only both this category is only single tender, so it's single bid.
It amounts to, lordship, in my humble submission.
Yes, Mr. Pandey. What's wrong with him?
It is, my lords, a single person has been selected. It's not a single tender. It's not a single bidder. It is the, say, this document is reflective of the person who has come out of.
Right. But as per instructions, where is only a single bidder or were there multiple bidders? Or single tender? What are we saying? What is the
Single bidder, lordship.
Yes.
Lordship, if I may place the rules, lordship.
No, let's hear them first. Yes, Mr. Pandey.
Milords, I am on the go, Milords. I am checking with the department whether there were multiple.
We'll have it on Monday.
Lordship.
Yes,
We can have it
a notice dated 15/9/2025 has been produced by the state respondents indicating the results of the bids for category 1, category 2. On a query from the court as to whether the successful bidders were the only bidders, Mr. Pandey please obtain instructions list on Monday. Yes.
Lordship, this matter, otherwise the pleadings are complete, it can be fixed for hearing, lordship.
Let it come first. We can dispose anytime. There's no hard and fast rule.
51.
This matter is relating. This matter is relating to setting up of the NRL depot in Umran Dairy, my lords. My lord, there was a direction from this honorable court by order dated, my lord, 6/8.
It's carried out on 8/8.
My lord, yes. So I received this report only this
So this
morning.
order, something wrong with this order. Should tentative date was 8/9 actually.
My lord, what happened was
errors there. In this order.
my lord, the first inquiry was held on the 1st of September. Then thereafter, the DC
wanted to do on 8th. You wanted to do
yeah, he wanted to do
there was a prayer for additional.
typographical error in this one. Who typed this one? Oh, that's what 9th.
My lord, that is order dated for.
Yes, it should read as 8/9/2025. Was it?
Yes, my lord, it's written as 3/9.
It was conducted on 8/9, my lord.
Then what happened?
My lord, I have received the report this morning. So the report indicates, my lord, if my lord.
It's all right.
It's feasible project, my lord. That's what
Then you bring on record.
Let it come by way of an affidavit in that case.
Yes, so we can, since.
Lordship, and for the NRL, we are also on the report, Lordship, and to file an affidavit on this.
Yes, Mr. K. Varasaji has produced a copy of the consolidated.
Constant noise.
Mr. Roy, can you please mute, or we're getting some disturbance?
Lordship.
No? Approves the consolidated joint inspection report in terms of the order of this court dated 6/8/2025.
Yes, my lord.
He prays aloud to place the same affidavit. Prays aloud, this after 1 week.
1 week. Lord.
Yes, take it back. Yes. We'll record your presence on behalf of the NRL. Yes.
52. 52.
My lord, here the short issue involved the respondent unable to call for a meeting, and when he called for a meeting, he excluded many residents. Therefore, we approached before this court, and lordship passed the order also. And this inhuman order, lordship has stayed. Page number, my lord, 49 of the writ petition. So it is a, if I may pray, my lord, may dispose of the writ petition, directing the respondents to conduct a meeting, including all the villagers. And with regard to my complaint pending before the district council court, let the district council court take a decision in due process of law.
1 second.
Please, Lordship. I'm appearing for respondent number 3 and 4 in this matter. Your Lordship, just to remind you, Lordship, this is the second round of litigation, and in the first round, your Lordship has already directed us to convene the Dorbar. And accordingly, we have complied and we have issued a notice also in order to all the residents in order to give them equal opportunity. But instead of coming to us, they have directly approached this honorable court, Your Lordship. So.
No, the entire controversy, my lord, is my lord will come to page 49.
Yes.
By page 49, my lord, the village committee, after receiving an order from the honorable court, has issued this notice notifying the names of the residents who are eligible to participate in the upcoming village Dorbar, which will be held shortly. The key points of this notice are as follows. Any residents whose names are missing, incorrect, or who have to make any necessary corrections are kindly requested to make necessary corrections, so and so. If there's anyone who wishes to remove the names from the list that has been notified, so what the village Dorbar tried to make a list and exclude all other villages from the election process or the Dorbar, or taking part in the Dorbar. So being agreed, and my lord will see page 51 and 52. These are the forms which had been prescribed.
Yes.
And so the petitioners, being aggrieved by this action of the Dorbar Shinong, they have approached this court. Now, in the meanwhile, a rejoinder has also been filed, it seems, by the petitioner here. What's your rejoinder?
What is in the rejoinder?
The rejoinder, my lord, they have also annexed a representation, which is dated 12th August 25 at page 7.
Yes.
Here the villagers have said they have lost confidence on the functions of the headman. My lord, it appears that the headman has not held a Dorbar for the past 10 years. That's the main grievances of
10 years?
10 years.
You're the headman?
Yes.
Why you held Dorbar 10 years?
Apprise, Lordship, we have convened a Dorbar But then, because
10 years ago.
Your Lordship, on 2024, Your Lordship. So, may kindly come to from my affidavit, Your Lordship. I have stated.
So there seems to be a lot of trouble. What I would suggest is that there should be a Darbar under the aegis of the district council. Let there be an observer.
CM is person.
It appears because AM, when they went to this AM also, the AM said he does not have a sanat. So I don't know.
The headman respondent doesn't have a sanat.
Doesn't have a sanat.
Yes, and refused to call for a meeting. And when he called for a meeting, pursuant to my lordship order,
So the thing is that
they excluded.
the CM doesn't recognize him also.
It appears. It appears.
Doesn't recognize him.
If there's no Sanat, Lordship.
Yes, yes.
Sanat is there, Your Lordship. Kindly come to my affidavit, Lordship.
So there's a lot of what I would suggest.
So there's more.
2014 Sanat, Lordship.
There's more to
what the
meets the eye.
Yes.
Like they say. Yes.
So I would suggest from the district council that there should be a Darbar.
But then if there's no headman, that issue, there's a core issue, it has to be resolved first. Whether he is a competent person to call for Darbar if he's a headman at all. If Sanat has already lapsed, then what happened?
Earlier occasion, my lord, at page 48, Your Lordship.
Where's your Sanat? MS Harsiyan. Where, which page?
From my affidavit, annexure 1, page 13, Your Lordship. Translated copy, page 14.
You need time limit.
No, Your Lordship, they have not.
That is again another. How can a sanat be issued without?
And they're not calling for meeting.
That this appointment remains valid so long as the community. Where's that? You wrote this number 6. Where does it come from? Number 6 is cross years.
It says confidence / dash. Yeah.
Okay.
So we have filed even a non-confidence motion before the district council. The complaint is still pending.
No, they should
The
file for
problem
the
is-
CM first. Did the CM take up the issue with regard to whether he's headman or not? Has it ever any proceedings initiated that to question his headmanship?
No, Lordship.
That should not yet.
Then why do you file directly to the council?
But the headman and the same did not take a action. Therefore, we raised a complaint before district council, which is lying. Only my prayer, my leave lordship direct to call a Darbar under the aegis of the district council. Then the issue can be considered by the
How can you
villagers.
bypass the CM then?
Or CM can depute.
At page 44 of the red petition would indicate. This is the a letter from the office of the CM of Hiram.
Page 44.
44, minute, the relevant page at 45. 45, my lord, will see this number 9, serial number 9.
NA.
Not available. Sanat. Number 9, Urkso Wapatao.
Yes, yes.
Yes. So there appears to be a lot of confusion here.
So
What did the
you stand by your submission that Sanat is valid? That you continue as headman?
Yes, Lordship.
Sure. So you're still de facto headman now also? Or you're in the... You're de facto headman?
De facto.
You're running the village?
Yes, Lordship.
All the schemes and everything?
The district council is only interested in the will of the people, not whoever.
Of course, that is the basic thing. But with only the correct procedure to be adopted, if we have to come to any resolution, that whether it's a district council or whether that the CM can manage it, and that he takes a call on whether he's a headman or not, and calls a Darbar to elect the headman and to do whatever necessary.
And my lord, just to clarify, lordship, it's not mandatory that the post of Rangbashnong is mandatorily held only for 5 years. It depends on situation to situation and villages to villages. This practice is across our Hima, my lord. It's not mandatory for a specific number of years.
No, that is correct. That is known. The thing is that if the people do not have confidence, and what meeting was this called? Directed by this court to have what can darbar?
Yes,
a general darbar.
Yes. My lord's order is there, page number. Page 47.
That was the first direction.
Pursuant to this, my lord, the headman appears to prepare the list and excluded many villagers. The reason being, we are the complainant, calling meeting number of years. He did not. The person's lordship order he called and excluded many villagers. And many names included in the electoral roll of the
Then we
village.
take it from the last order. Then you. But who will be the observer for this meeting?
That is this council, my lord, because the last occasion also it was the district council.
Now, how do you ascertain who are the bona fide residents of?
Well, I think
My lord, the electoral rolls are there. I have an
electoral roll.
Electoral rolls are
That is
there.
not possible, Your Lordship.
Electoral roll, you're not relying on electoral roll.
No, because Your Lordship, many residents, they are like, they are not like, residing in that village anymore. So we cannot just allow anybody to participate.
So they just come and vote. They don't stay there.
Yes, Your Lordship.
I mean, for the general election, I'm not talking about this.
Yes, Lordship. They are no longer staying in that particular village, so it's not possible, Your Lordship. And we have already prepared a list of eligible participants, Your Lordship.
Who will vote for you only?
Around 900 something, Your Lordship. More than 900, Your Lordship.
But Lordship, just in continuation of the same, my lord, it is a fact that as per the
Electoral roll.
electoral roll, sorry, Your Lordship, it is a fact that many they shift residence, but they maintain their voting.
So that means won't have a right to sit in the darbar.
But Lordship, if they have
can
moved
vote
to
for
another
the-
place, then they might have entered to the darbar. Maybe they are participating in the new darbar of their new village, Lordship. That's a common practice everywhere, Lordship.
And Your Lordship,
They may stay in Shillong, but they are the bona fide villagers. So whenever their party is called, they used to participate. But here is, my lord, the exclusion.
No, that's correct. But the thing is that how can a mechanism be devised that only the people who are staying in the village itself will be voting. You have to go door to door, take down the names. There has to be some other kind of vibe.
Otherwise,
there.
also in the village, also they have the registers. No? Otherwise, in other
But
villages-
registered in the custody of the respondent,
Yes, that
he
is
cut
the
out
only
the
problem.
names of those people. It's not inimical to him.
Your Lordship, actually, in fact, we have already issued notice.
You cut the names of all those.
No, Your Lordship, in fact, we have allowed anybody like to...
No, I'm saying you cut the names of those people who don't stay from the electoral roll, or what is it?
No, Your Lordship, because they are not eligible, Your Lord. Because...
No, what this court is saying now, for those names from electoral roll itself, who are not staying there, you identified them.
Because they are no longer the religious...
No, I mean they've been identified. They don't stay. So according to the respondent's headman, that they should not vote. Those people have been identified.
Your Lordship.
Is this petitioner a resident of the village?
Yeah, they are the resident.
Or he stays in Shillong?
They are the resident in the village.
How many petitioners are here?
My lord, the authorized, many of them are excluded. And the authorization letter is
How will we do, intensive revision from the court?
difficult.
So how do you propose whole election?
We may come tomorrow also, Your Lordship.
You take instruction. What is your proposal? Suppose fine, whatever it is, he might be a de facto headman, though he might not have a sanat. That's besides the point. But the darbars are convened even to elect headman or for other things. Now, how do you propose to do it? That's why you made the form. So, Mr. Chamarisu is saying that even filling the form also you'll be entitled to vote.
Then if we go by then, my lord, whoever fill up that form, he or she will become the voter. That is incorrect, my lord. They have to follow the electoral roll. Many people are residing in different parts, but they used to come and participate. If I may suggest, my lord, for impartial preparation of the list, if lordship direct the chief to prepare the list after giving portion to all the villagers.
Chief doesn't have even the resources to do that thing. Why should he take the exercise?
Or is the district council, my lord? Because the headman is taking a different view. He's the custodian of all the records and not disclosing any.
No, the only thing is the thing is that the safest is whoever is there in electoral roll.
Yes.
Yes, sir.
They should.
They should be
Yes,
allowed.
yes.
They should be allowed. And now then we'll allow the respondent ever to say these people from electoral roll object to the names who are there in electoral roll as they're not staying there.
My lord, the constituency is quite huge, lordship. The constituency.
It's not one village.
No, it's not constituency, it's a village.
The village.
The village electoral roll, sorry. But if we are not residing there, my lord.
See, in the electoral roll, see, names are given, polling station, main town, Utsav, Wapatha, all of them. What this court's proposing is this. Now, tentatively, that whoever is registered in Urksau Wapatha as a voter and in this government electoral roll will be considered a potential voter, right? And if you have objection to some of them who are not staying there, then you personally will have to undertake the exercise.
I think that will be fair, lordship.
Give them a notice.
Yes, you give notice. Now the tentative electoral roll for the people will be those that appearing in the electoral roll. So if from there you pick out which ones you see are not staying there. Then you put up the list. And so these people are, then they'll come forward. But otherwise, how will you work out something which will, balance the equities, like you say? What to do? You are agreeable to that?
I'm agreeable.
You take instructions.
Will it come next week?
Yes.
Yes, on hearing the matter, the tentative view of the court is that the electoral roll of the election commission for the village Urksau Wapathaw be the base for determining the voters who can participate in the Darbar. Is also the tentative view, is also observed by this, is also on the objection of the council respondent 4 and 5. 3 and 4. Perhaps one objection of respondents of 3 and 4 to submit that though some persons' names appear in electoral roll for Urksau Wapathaw, they are no longer in the village and as such would not be eligible to take part in the Darbar. Thus, it is further provided that the respondents 3 and 4, here the headman, 4, no, it's just, no, not yet. Thus, 4, no, done. But this court in this point observes that perhaps the respondent number 4 be given also the opportunity to point out the names of those said people, of the said people who are not residents, and to prepare a list thereon. Learned councils to obtain further instructions without a wait. So that is the tentative view.
Much obliged.
Or you put up a list, you say these are not residents.
53.
Wait, please, Your Lordship. Your Lordship, we filed our affidavit.
So we'll filing for rejoinder that affidavit. Filing rejoinder, Your Lordship, in this matter.
Yes, Mr. Smaitan, for 2 weeks time for the rejoinder after filed by the respondents.
Obliged, Your Lordship.
54.
Your Lordship, we have received the affidavit in the last occasion.
Filed by which respondent?
Filed by respondent 1 and 2.
Yes.
We request for 2 weeks time, Your Lordship, to file rejoinder.
3 to 5 filed. 3 to 5.
No, state has not filed.
Yes. Your name, sorry?
Dealing dog.
MS Dealing Dog, please for about 2 weeks time to file rejoinder with affidavit filed by respondents number 1 and 2. Yes.
55.
Yes, my lord. I'm appearing for the petitioner. My lord, I have received affidavits from the UPSC, that is respondent number 4. I'm yet to receive affidavits from...
55 is wrong. 55 is another.
55, no?
Mr. Paul or Mr. Chanda?
This is different.
I'm sorry, my lord.
Lordship, insofar as this matter is concerned, Lordship, the only grievance now that is left, Lordship, is with regard to the second FIR, Lordship. Because with regard to the first FIR, Lordship, they have taken action, Lordship. Statements have been recorded, but with regard, Lordship, but let them take an action, Lordship, if that may be recorded. That
is a continuation of the same offence, correct?
But Lordship, what has happened is that, Lordship, on the 20th,
first FIR have taken action.
We have taken action and completed investigation. And second FIR, Lordship, it was not received in the.
They say, my Lord,
they
say, my Lord, it has not been received. But we are saying, my Lord, the private respondents in connivance with the police, my Lords, are acting, Lordship, and they have not received, my Lord. In fact, to that effect, Lordship, when this particular complaint of 20th was not received by them, we had again written to the SP, Lordship, of the concerned district, Lordship. So it's a serious, Lordship, thing that they had trespassed at night, Lordship, at around 12, Lordship. So, Lordship, if any direction be passed, that let them register the second FIR, Lordship.
They have made a categorical statement. No subsequent FIR received from the complainant.
But we have gone, Lordship, but I was ill-treated and I was sent back, Lordship. That is my contention, Lordship. Therefore, Lordship, I had
to come. What is registered the first case?
Second case, Lordship, is again on a different premises, Lordship. The second FIR, Lordship. Let them register the FIR and let them investigate, Lordship.
In regard to land dispute, correct?
Land dispute.
Lordship, I am not on the aspect of land dispute. I am purely on the question.
Rise of land dispute.
Lordship.
Yes.
Two rival groups, my Lord.
Maybe, my Lord, but then the enforcement authorities, my Lord, ought to have acted, Lordship.
Where did we get that information that it's not been done? That's the only thing.
My Lord,
if the FIR is not received by them, what other recourse do we have? Do you have?
Well, if Lordship directs them, then this FIR.
There's no FIR.
There's no FIR.
According to them, they never received second FIR.
My Lord, we went, my Lord, in fact, on the next day, very next day, only morning, with the complaint. It is part of the writ petition, Lordship, at Annexure 4, that is page 38, Lordship. Whereas it is categorically written, Lordship, that they had trespassed.
Page?
Page 38, Lordship.
This second FIR, 21/4/25.
Lordship, and when, Lordship, there was no action from their part, Lordship, we had again written the same thing to the SP of the concerned district, Lordship. That is on 29/4, Lordship, 2025.
29/4?
29. That is at page 39, Lordship, and Annexure 5.
What's the date?
Date, Lordship, right? Second line, Lordship. If I may read, Lordship, the last paragraph.
What do you want now?
Lordship, what I want is the second FIR, let them register and let them investigate, Lordship. This because, Lordship, it's a serious offence, Lordship, which has been committed.
Now, can they achieve anything? This happened when in 17/3. Yes, Mr. Kharmi.
Lordship, it's not there, that FIR, second FIR. Before the office of SP also, it was not there.
Then this letter was received by the office, by the SP?
No. It was not. It was not received.
Then nothing shows that this letter was ever sent to the SP, Mr.
There
Chanda.
is no.
Lordship.
21/4 or 29/4. There's no.
We have gone,
There's
Lordship, and we have submitted.
proof of receipt.
There's no
Lordship,
receipt,
Lordship. But we have gone, Lordship. We have gone and submitted.
One, that's your word only.
Lordship.
There's no acknowledgement receipt also.
That's what the court is looking for. Even a seal of the SP's of that they received this complaint. We'll close it, though it has been submitted by Mr. S. Chanda that in spite of a second FIR has been lodged, the police did not register a case. Commerce H. Kharmi has vehemently submitted that no second FIR was ever received by the police, and that as per the and submits that on the first FIR a case has since been registered and investigations also completed.
Completed and charged.
It's completed, and
Notice has been issued to the
accused have been charge sheeted.
Yes.
Have been charge sheeted. Stop. This court has perused the annexure 4 and 5, which is stated to be the complaint made before the officer in charge, Pulbari Police Station, dated 21/4/2025, and also a letter addressed to the Superintendent of Police, West Garo Hills, Tura, dated 29/4/2025. However, there is no the factum of receipt. However, the factum of receipt of these two letters is not evidence in the materials in the said letters. Stop. In view of this, the court therefore is inclined to accept the submissions made by learned government advocate, senior government advocate, that there was no second FIR. Stop. However, be that as it may, you file a criminal complaint then. However, be that as it may, in spite of the investigation being completed, the writ petitioner is at liberty to take other steps in accordance with law, such as by filing a formal complaint against the accused persons, against the respondents. I will close the matter. Yes. Next paragraph. In view of observations above, the matter stands closed and disposed of.
56.
Yes, my lord.
My lord, I require 2 weeks time, my lord, to file the affidavit, my lord. We have received the instruction.
On behalf of? Yes. You are appearing for the state?
No, my lord. I'm appearing for the private respondents.
Then who's appearing for the state? You ready? You ready with the matter?
Ready or not? Because the Advocate General will be here there, my lords, physically. Although the matter is covered by section 64 of the
that is why that is resisted by the petitioner.
Yes.
Today also Mr. S. Pandey's, not today also, as the applications are available, Mr. S. Pandey on behalf of the respondent praise the matter after 1 week. Yes, praise aloud. Yes.
58.
May I please, your lordship?
Go file.
Affidavit filed, my lord, but only, my lord, my humble submission is, my lord, the affidavit they have filed by the state has not produced any document, any marks, how many, which candidate having what marks, my lord. Even
what was the matter about?
My lord, the petitioner has participated in the selection process for sericulture, my lord. And after that, my lord, the DSC, my lord, has conducted the written examination, then interview, and I've selected in the written examination, but no marks were displayed. Only roll numbers were displayed in the result of the written examination. After that, my lord, the DSC has called for the personal interview. In the personal interview, the petitioner has participated, and after the result were declared, only roll numbers were, as per the roll number, those candidates were selected for appointment, my lord. Kindly have the impugned order, my lord, at page 19, my lord, annexus 6, my lord. Sorry, my lord, page 20, my lord, annexus 7, my lord.
Yes.
The results of the interview to the post of sericulture demonstrator conducted by the District Selection Committee on 9 June 2025 is hereby declared. The names of the successful candidates recommended by the committee in order of merit are as follows. My lord, this is the merit list after interview. But my grievance is, my lord, the result of written examination and the interview were declared, but no marks, no merit, no marks were displayed, my lord. Even I, as a petitioner, I don't know, my lord.
What does the affidavit say?
So my friend is agree with the procedure that we have adopted in maintaining the entire procedure. Now, what my friends wants is my affidavit should be drafted as per his liking. I should produce documents that he wants. He could have filed an RTA. He can take that up in his rejoinder. For some reason, he's delaying the matter saying.
No, what is your main grievance in the?
My main grievance is, my lord, as per the rules, my lord,
yes.
the contact rules, my lord. My lord.
One second.
My lord, declaration of page 27, my lord. Declaration of final results, my lord. Page 27, my lord. Rule
27?
Page 27, my lord. Of my petition, my lord.
27 is something else.
My lord, is the rules, my lord.
Okay, okay, yes.
Yes, my lord. The rules start from, my lord, page
4.7.
21, yes, my lord. But page 27 is 4.7 rules, my lord.
No.
Declaration of final results, my lord. The number of selected and recommended candidates shall be restricted to the number of vacancies advertised. The list of recommended candidates shall be displayed on the notice board of the district selection committee immediately after the interview and communicated to all the concerned authorities. In no case shall the number of recommended candidates be larger than the number of vacancies as advertised. It would be incumbent upon both the chairman of the district selection committee and the member secretary to ensure that above provisions are strictly adhered to, and failure to do so may entail departmental proceedings being drawn up. The list forwarded, my lord, kindly have page 26, my lord, 4.5, my lord, declaration of result, my lord. Though no cut-off marks were set up by the respondents, my lord. 4.5, my lord, page 26. Declaration of results of written examination. Cut-off marks shall be fixed as per the benchmark/standard depending on the number of vacancies to be filled. After declaration of results of written examination, individual marks secured by the candidate shall be kept in seal cover and opened only after personal interview at the time of tabulation, my lord. My only grievance is no cut-off marks were set up by the respondents, my lord, before conducting the examination, my lord. Whereby, my lord.
So your grievance is that you want to know how much you scored.
Yes, my lord.
So what are the cut-off marks?
What is the cut-off mark? Without knowing the cut-off marks.
What did they say in the affidavit?
My lord, in the affidavit, they have just relied on, my lord, the same rules, my lord. My lord, para 8, my lord, page 4, they have relied on the rules, my lord. 4.5, the same rules, my lord.
Okay. They see the cut-off marks, they will not disclose it till after the interview.
Yes, my lord.
Now it's over.
Now it's over, my lord. Interview is over, my lord.
Yes.
My lord, if...
1 second. Yes, what more you have to say?
My lord, if may permit, my lord, I want to file rejoinder to counter some points. My lord.
For rejoinder, the thing is that now what appears without even looking at the marks, it didn't qualify.
My lord.
So that's why, because you see, they say that furthermore, when cut-off marks is concerned, reiterate that cut-off marks shall be fixed as per the benchmarks or standard depending on the number of vacancies to be filled, and also total number of persons whose result is such to be declared should in no case exceed 2 times the number of vacancies, and view the same as herein stated corrigendum dated so and so indicated there were 14 posts, out of which 3 for unreserved, 10 for and none for OST SC. However, no candidate belonging to OST SC category appeared for the exam.
Yes, ma'am.
You SC?
No, ma'am. General category.
Oh, as such, 11 posts will be filled.
Yes, ma'am.
So, you file rejoinder.
I'll file rejoinder.
That's what I'm saying. They should file a rejoinder.
I'll file rejoinder.
Yes, that will be accurate. Mr. SK-san, please sponsor out 2 weeks' time to file rejoinder. File the response thereafter.
Hello.
We thought that you would have wanted a disposal today itself.
59.
Please, Your Lordship. Your Lordship, the matter has not settled in Lok Adalat.
Not been settled.
I pray for 2 weeks' time, Your Lordship, to file an affidavit.
Is the matter since returned from the National Lok Adalat and on not being settled, this up to 2 weeks for
Affidavit, Your Lordship.
for rejoinder.
Yes, in term of last order.
No, Your
Rejoinder.
Lordship, not rejoinder, Lordship. They're supposed to
file the
affidavit bringing on record all of the dues that has not been paid to them.
On not being settled. MS P. Motion.
Yes, Your Lordship.
Praise for 2 weeks time to file additional affidavit.
Yes, Your Lordship.
Praise allowed, yes.
Item 60.
Yes, some. Where's the affidavit?
Lordship, I'm praying for 1 week. It's prepared. I'm just awaiting signatures, Lordship. 1 week time, I'll file.
You have to make your response appear in person.
Lordship, this is the second time I am just praying for time. 1 week time, I'll file it.
We want to see them and
I
ask them what is the role in society.
Lordship, I have prepared the affidavit.
Are they
just
only
awaiting signatures.
serving themselves or serving society?
Lordship, all we did is we lodged an FIR. We got certain videos.
What is your basis? How you're a person agree with that?
Lordship, we are an NGO in that area. We got a lot of videos and photos and complaints with regard to the agent collecting money without issuing any receipt from the checkpoint. And we lodged an FIR. That is all we did, Lordship.
Okay, when are you filing? Mr. Rompuer is filed.
Filing.
That's what the day. When are you filing?
How the district council came to the decision is not within our.
That is the thing that is what we want to unravel.
Correct. That is
as to how there no other consideration, only on your complaint.
I understand.
That's why we are very interested in hearing what is your stand.
In fact,
on your
as far as
complaint.
my instruction goes, we were not even called for before they passed the road.
How it all plays out is very difficult to understand. Some third party motivation is always there. Oust me and get into my place. Something of that sort. By using an NGO.
So you like mercenaries?
No, not at all, Lordship. We had simply lodged an FIR, and we are not the only NGO who has lodged an FIR against the particular agent.
Yes, Mr. Ahmed Nampur on behalf of respondents number 1 and 2 and Mr. S.
Number
Dev
6.
for 1 to
1 to 5.
1 to 5 and Mr. S. Dev for 6. Allowed 1 week for a time for affidavits. That's very curious, that's why.
I understand.
We can understand cancellation of leases on other considerations, but on that consideration, very curious. Is that your behest? It was cancelled by using third party.
In fact, after we lodged the FIR, when that clarification came out in the newspaper, we were about to come to the court. But in the meantime, it appears.
So they have some motivation, very serious motivation in this
So
matter.
that's why it's very curious. Now, is it at their instance that you file FIR?
No. I had filed an FIR long before.
Independently,
Lordship. They never replied to
Being
my
a
FIR.
responsible NGO.
Lordship, yes. I sent a legal notice that you should not run this check gate. They did not do anything. I lodged an FIR saying that people.
You file an affidavit, would be interesting.
Lordship.
61.
61. But here, once I'm appearing for the MTDC, I'm praying for 2 weeks' time also to file my affidavit.
Yes. For the 2 weeks' time, as prayed loud for affidavit by the respondents.
62.
Yes.
I'm praying for some more time, Lordship.
Why?
Before I receive instructions.
Last was 3 weeks, 26/8. For 2 weeks' time is allowed to the respondents to obtain instructions of affidavit. Yes. 4 to 2 weeks time as prayed.
63.
As per the last order, my lord, steps were taken on respondent number 4 and 5 and 6.
Where's Mr. Abraham? He's sleeping. He's not here. Yes. You're a conducting counsel for the state?
Yes, sir.
Yes.
I mean, given your lordships some time.
You don't have the file with you also.
Actually, the brief has not been endorsed to me. I was just on last occasion. I was just appearing on behalf of the state.
The matter?
Yes, Lordship.
No, on behalf of the state.
This is which I can.
63.
Oh.
Also indicates that this is not complete. On
Yes, Lordship.
Yes.
We have filed an affidavit, Your Lordship.
Or for a 2 weeks time to file affidavit. This up to 2 weeks for affidavit and for service report.
Okay. Highly obliged, Your Lordship.
64.
Lordship, we've received instructions. We will be allowed 2 weeks time to file our affidavit. This is regarding work charged employees.
None appears for the petitioner. Stop. Next line. MST Yangi B response allowed. PAG allowed for the 2 weeks time to file affidavit.
65.
Please, Your Lordship. I'm praying for some time, Lordship, to file our affidavit.
Affidavit.
All respondents here. Please, all respondents. Yes, sir. MS Ember Chang also. Vice also praise for the 3 weeks time to file affidavit.
Second call. Item 39. 39.
Where's the RP General?
Well, he's still on legs. Mr. Pandey will be arguing on his behalf.
Where's Mr. Nongri?
He's on his section.
So we posted next week when you hear physically.
My lord.
Yes, my lord. Mr. Pandey submits that the attention is still not available due to other engagement stuff. He, however, submits that perhaps the matter can be taken up physically after 1 week. Yes. Today is allowed this after 1 week, yes. But he will do it physically. On next date we'll discuss. Yes.
Supplementary 1, item number 1.
Why increasing firepower? It means make the case better.
My lord, yesterday my learned friend had moved this matter. Lordships had one particular query. We filed an additional affidavit to bring that on record. Please have the affidavit page 2, para 3, my lord.
Yes.
This to indicate when the parent of the candidate had joined his services in Shillong. Para 3, my lord. The deponent states that in response to the query raised by this honourable court by the order date so-and-so as regards the tenure and length of posting of a father of the writ petitioner, the deponent humbly begs to state that my father joined the headquarters Director General Assam Rifles Shillong on 22/6/25 and is posted with Assam Rifles Construction and Maintenance Company, Light Corps, Shillong, Meghalaya. Now, the reason for the urgent mentioning, my lords, will kindly see page 4. This is a notification dated 16th September 25.
Yes.
Posting the matter for counselling. The first counselling session is due to start on 19th September 2025 on Friday 9 AM. We may not have enough time. We're only asking for some sort of an observation, either a stay order or some sort of an observation that will be subject to the outcome of the writ petition. Now, I understand Lordship's query was with regard to these particular office memorandum. If your Lordship will kindly have the writ petition, will it? Because at first blush it does appear, why would a person who's just joined on deputation or transfer be entitled to compete for these posts?
Yes.
My lord, just before I take your lordships to this OM, I'm referring to a particular judgment to it which will clarify what really happened here. 1983 4 SSC 339. So these seats that are kept for states which are otherwise deficient in medical colleges, my lord, this matter dealt with that particular issue. Please have page 341.
Yes.
This relates to the state of Jammu and Kashmir. I'll just read the facts from the first paragraph, my lord. This court has had occasion in the past to entertain the complaints of several young men and women who aspired to admission to the medical colleges of their states and have been wrongly denied admission thereto. In the writ petition and civil appeals now before us, the grievance voiced by the petitioners and the appellants takes us to the new category of cases and to a new dimension. They question the validity of nominations by the state government of Jammu and Kashmir and the state government of Andhra Pradesh of candidates to seats reserved in the medical colleges of other states. So states which are otherwise deficient in medical colleges, they are given nominations by the central government. So seats are reserved as part of the central quota. Please see the next line, para 2. The Medical Council of India in its report on undergraduate medical education recommended that with a view to encouraging national integration, 10% of seats in every medical college other than those where admissions were planned on an all India basis should be reserved on a reciprocal basis for students from other states. Now in this case, what had happened, there was an arbitrariness adopted by the state in filling up these seats in the selection process, and this is what the state finally held at page 345.
Yes.
Para 10, my lord. In the result, we allow the writ petitions and the civil appeals insofar as the principle adopted by the state government of nominating candidates in their absolute unfettered choice to seats in medical colleges outside the state is declared invalid. Now this is important, my lord. The Medical Council of India is directed to formulate a proper constitutional basis for determining the selection of candidates for nomination to seats in medical colleges outside the state in light of the observations contained in the judgment. So MCI was required to set up some sort of a policy having some sort of a constitutional basis to fill up these seats. Now, pursuant to that, in my humble submission, and this is subject to what the union may have to say about this, please have the OM at page 21 of my writ petition, my lord.
Yes.
So I'll read the first page, the letter dated 28 July 2025. Office memorandum, subject guidelines for allocation of central pool MBBS and BDS as well, my lord, both for dental as well, seats for the academic year 2025-2026 regarding. The undersigned is directed to refer to the subject mentioned above and to enclose here with the guidelines to be followed by the beneficiary government. Please note this, by the beneficiary government departments for selection and nomination of candidates against central pool MBBS BDS seats for the academic year 25-26 for the information necessary action. So it is a state government which decides which beneficiary state will get how many seats. Then please turn to the next page. My lords have it, page 22. Guidelines for selection and nomination of candidates against central pool MBBS seats for academic year 25-26. Selection of candidates by beneficiary states, union territories, beneficiary states UTs. The state UTs which are deficient in medical education, only these are the beneficiaries. Eligibility conditions, only the children of, number 1, permanent residents of state UT concerned. So these are the people who will include indigenous people as well as those who have PRCs. This is one specific category reserved for those people. 2, the employees of state UT government concerned, second category. 3rd, the employees of central other state UT categories on deputation to state UT concerned. Well, let's just pause here for a moment and consider this. A person who's on deputation, maybe on deputation for 6 months, 1 year, 2 years. How will he be entitled to get a PRC? I've just inquired from my friends at the bar. Today in Meghalaya, the PRC requirement is 12 years continuous stay in Shillong. Not possible to get a PRC for somebody in deputation. The purpose here is very clear. These people are serving the state. They keep getting uprooted from one state to another state. Their children lose their friends, family and all of that. So just as a mark of recognition for this, they are given a platform to compete. They're not being given the seats for free, only a chance to compete, that's all. Please see the next one also. The employees of the central other state UT government posted and having their headquarters. So it's qualified by the fact that not every single person who's transferred is entitled, only those people who have their headquarters. In my case, my headquarter is here, DGR, and I've specifically stated that in my additional affidavit as well. So they've created purposely this with a salutary objective in mind, that those people who are constantly being uprooted, the central armed police forces, armed forces.
So you mean to say it covers the armed forces also?
Yes, yes, my lord. Yes. Everybody. They're all central government employees.
Do you have any authority to show that on the basis of such an OM analogy or something that, that admission was given is paying for 2 months?
Well, no, but that was my explanation. So this direction of the Honorable Supreme Court, the MCI or the central government has to come up with some sort of a policy. This is the policy, my lord. So on the basis of this policy, they decide the guiding on the controlling norms and the controlling guidelines. The state cannot decide to come out with something which is inconsistent to these guidelines. So as far as the PRC part is concerned, this covers serial number 1, permanent residents of the states. They're all covered here. And they're going to compete on merit, my lord. It's not a clear reservation as such. So what we are saying, what has been done by the state, they cannot decide to not follow this. They are only a beneficiary state. So I am giving you some seats for your benefit. You decide to make rules inconsistent with the original controlling guidelines. That is absolutely impermissible, arbitrary. So what I was saying, these are seats which are allocated for the central and state government people who are on deputation and on transfer with a salutary objective in mind. That should not be defeated, my lord. And please consider, in our particular case, the petitioner has travelled from Manipur. They are posted to different, very difficult terrains. At this point, they leave the school, they leave their school friends. And these are, for children, it's a traumatic experience. This has to be taken in, and I suppose this is what was taken into
consideration. Children are the best. They're very, they respect diversity, and
yes,
I've had, it's not that they, in fact, everyone should be given a
yes, absolutely.
Life. They travel all over the country.
Yes, my lord. So these people are moving out from Manipur or whatever difficult terrains they come from armed forces.
Where was he posted before?
Prior to this was Manipur. From Manipur, they're here in Meghalaya now. Yes. My lords will also see page 23. Just to point out what the objective is. There's an additional objective here.
In other state deficient in where can you show that similar situation existed and whoever in another state, maybe Sikkim or Ladakh?
Please see page 23. This OM itself takes care of this situation. I'll give an example of the UTs of Jammu and Kashmir and Ladakh. Page 23, serial number 2. Selection of candidates by UTs of Jammu and Kashmir and Ladakh. Eligibility conditions. Central pool MBBS seats are being allocated to the UTs of Jammu and Kashmir and Ladakh for selection and nominations of the candidates from the UTs of Jammu and Kashmir and Ladakh.
I'm saying about what has happened now with admission.
Yes, my lord.
Whether anyone else who's been serving the forces in the other part northeast has availed of this facility.
Off the hand, my lord, I don't have that information.
No, they'll know. If you're in the forces, they'll know.
Possibly. They should know.
Then?
I'll have to take instructions as far as that is concerned. But as far as forces are concerned, my lords, please see that parrot what I was coming to. I'll just take a moment, my lord.
Which one?
This page 23, serial number 2.
That is Ladakh and this Kashmir are given different consideration.
Yes, my lord. What does it say? Children of families who are terror victims. Please see 2.1.1. Children of families where a parent or direct member of the family has been killed in acts of terrorism or has been an innocent victim. So, well, there is a different classification created for different people.
They're exposed to risk.
Yes,
even for disability, ex gratia also is higher if you're killed by terrorism.
So, the analogy I'm trying to draw as far as 1.2 is concerned, as far as those who are permanent residents of the state, they are not being deprived. They are contained under serial number 1. They have a right to participate. They've created additional classifications for state government employees as well as those on deputation from central government and on transfer. Otherwise, kindly consider somebody is being transferred from Manipur to Meghalaya to Jammu and Kashmir. Their children may not have an opportunity. They cannot get a PRC in any state. It is impossible, and especially for deputation.
Yes, Pandey, who's appearing?
Pandey, madam. Yes, my lords, I am appearing, my lords. In this case, my lords, as I, my lords, earlier pointed out at page 43, if your lordship sees page 43 of the repetition.
Yes.
So, my lords, this candidate has indicated that she is
staying in Haryana only. She's not staying with her father here.
Yes, this is from? This is from 23, my lords. I have said we are transferred here in 25.
No, is she staying with her father here?
Yes, yes. We just met her. She's filed in Shillong, my lord.
No, I mean she did the examination from Shillong.
No. The examination is somewhere in Haryana.
Where the examination is held? In Hisar?
The Hisar, my lord. Which so it's not Shillong, my lord.
Yes.
Or Manipur, my lord.
Yes.
What I can see from the affidavit, my lords, which has been filed today, the father got shifted to Meghalaya on 22nd of June 2025. The declaration of result as far as NEET is concerned happened on 14th of June. So after the declaration of results on 14th of June, he has been transferred on the 22nd of June 2025. Anyways, he has no, she has no Milord's case in this case, and
why
she
is
is
that?
admittedly carrying a residence certificate of Haryana at page 43. So,
A NEET exam came out before he was transferred.
But Milord, how would that have any difference? Milord? Why I'm saying is the eligibility condition itself provides anybody can come through. I'm being transferred soon thereafter. If I'm being
once you apply in Manipur, while he was there that time after NEET result.
No, I'm saying, Milord, this happened in 26. I came in here in 2025, and I am eligible otherwise. I'm otherwise eligible, Milord, because the state is saying I'm eligible. The union is saying I'm eligible. The state says you're not eligible. Now the question is only this: can you deprive me? Milord, kindly consider this. Please look at the advertisement of the state. It is absolutely inconsistent and in violation of the guidelines. Please have page 18.
Challenge that.
Please have page 18, Milord. Let us see if they've included any of these eligibility criteria. They've removed everything completely. Please see serial number 1, eligibility of medical students studies. Only candidates who are indigenous inhabitants or permanent residents of the state. Everybody is excluded.
Yes.
Those who are on deputation, those who are on transfer, everybody is excluded. How is this consistent with the guidelines?
Have we challenged this? Is it impugned?
Specifically, we have not challenged this particular condition, Milord. I'll just point out why. Please see this, Milord.
Today by the
last document, Milord. Just last document. Please see page 59.
Yes.
I'll explain what the reasons are. Because I was sought to be excluded, please see, this is a letter I've written, an email on 11th August 2025 at 2 p.m. I'm a resident of Haryana. My father, being a central government employee, is right now serving in Shillong, Meghalaya, and the headquarters is located in Shillong itself. I wanted to know whether I'm eligible to apply for MBBS seats, central pool quota. According to the guidelines of the Ministry of Health and Family Welfare India, copy attached below, I have the eligibility, but there's no such criteria mentioned in the advertisement released by the government of Meghalaya. And please see the response at the bottom. The last line, Monday 11th so and so, we will update you when once we get approval from the competent authority. This is the state government replying to us. We are asking you, how have you made this kind of an advertisement which is contrary to the central guidelines? And they say we have to take instructions from the competent authority. This is as late as 11th of August. They're yet to give me any sort of a response, and in the meantime, they've started the entire process of the counselling sessions. That's all I'm only praying. Limited prayer. I don't think it will cause any prejudice to anybody.
See, the thing is that you're on a larger picture.
Yes,
maybe it needs what do you call it, a policy decision again. See, we can't pass orders which will,
No, my lords, I'm not asking for that. Lorships are going to consider my writ petition only a minimum observation, my lord.
By the writ petitioner. Your report notification dated 16/9/2025, wherein the counselling has been scheduled to be held on 19 December 2025. At this stage, the state responded to find affidavit on the eligibility of the writ petitioner, in as much as the same is still unclear from the materials that have been presented.
Well, it's most important the union as well will have to clarify this, and only
union there's nobody.
No, I think she's a place she can always inform.
Yes, sir.
It's only a minimum observation.
Instructions, yes, for affidavit as well as this union.
This observation will be subject to the outcome. This will not prejudice anybody, my lord. In case I'm successful,
even the very right of whether regarding that aspect of the father need before the father is transferred here, whether prospectively you can so that's not a factor.
I'll
the thing is that we would consider, this court would have actively considered the matter if the person was posted here and serving for 2-3 years. Then that would have been understood that the girl studied here. Like you're saying that she's been dislocated from her and home and come to a forbidden place.
So that is the objective behind it.
So
that's the objective that I understand.
So, you see, that consideration would have given. That's why this court yesterday said that how long the tenure is only in June. So that's the thing that's gone against you as well.
Lordship, but then again the thing is that the state makes a advertisement which is completely inconsistent.
There will be a champion for later cases. Yes.
Hearing?
For 2 weeks. Yes.
Will you consider just a minimum observation, my lord? Yeah, obliged.
Don't want to rock the boat. Otherwise, other things might come on.
Hearing 66.
Start the hearing.
Lies.
Where's Mr. P.T. Sangma? Oh no, S-Deb.
Your Lordship, he's on leg. Your Lordship, I prayed let the matter be taken up after the at the end of the board.
End of the board?
Your Lordship.
We already at end of the board now. Yes, you ready?
Lordship, auditor is there.
Who?
Mr. Pandey is there, Lordship, online.
Yes, my lord. This is the election petition. Manang D. Shira Millards and
where is Mr. Dev?
He's on leg. In court number 3, Your Lordship.
We take up 215.
Your Lordship.
But if we take 215, you better argue it on 215. It's not no adjournment be given. Not that it happens every time. In 215 they come and seek accommodation.
Your Lordship, then let the matter be taken up after week.
Then you have to put in an application. Yes, put in the adjourned application for 1 week.
Much obliged.
67.
This is a contempt application, my lord. They are yet to comply with the order, my lord.
Yes, Mr. Abraham. Where's the order? This order of Justice More.
My lord, even my lord also in earlier contempt petition, my lord has given an order. That is page number 17.
What compliance they have to do?
Here also, my lord, here
to conduct a special interview.
Yes.
Have you conducted that?
No, on the day when the order was passed, we have communicated to the personnel department. Then the personnel department, we have written to the MPSC to conduct a special interview. Then the MPSC has directed us to be routed through this personnel department. Then we have written a letter to the personnel department to conduct a special interview. Then the personnel department has written a letter. They said that that roster policy has to be followed. So then,
what are you submitting with Abraham? He's running around. I can't. Running around in circles. This. He went to.
We have written a letter.
See, basic thing is there's an order of the court. Okay. What is the letter and spirit of the court's order should be complied with?
Yeah.
Has it been complied or not? Yes or no?
No, Your Lordship.
Then?
Well, the reason is that
contempt.
No, Your Lordship, is this. If I'm pleased to address Your Lordship for 1 second, Your Lordship. Actually, there was an order to conduct a special interview. They were actually the petitioner was appointed under F3F.
No. One thing, Mr. Sinkan, who have you made as only the industry department?
Yes, the secretary and the director, Your Lordship.
Then MPSC you struck off.
Struck off, my lord. They have prayed for striking of their name, my lord.
Because this 3F, it is the MPSC who has to conduct. And we are from the
not MPSC to conduct. 3F is what?
This is under 3F. Your Lordship, please. There was an order to conduct a special interview. Then we have complied it. We have written a letter to the MPSC to conduct a special interview for the petitioner, 5 of them. Then the MPSC has written back to us, inform us that it has to be routed through this personnel department. Then we have written a letter to the personnel department.
Where's the letter where it said roster? Where?
Roster.
You said that they said that we have to follow roster. Where's the letter?
That is, if I'm pleased to take Your Lordship to my affidavit filed by respondent number 2. It is 8 page 35. Page 35. Page 35, Your Lordship, of my affidavit filed by respondent number 2, page 35.
When was this issued? After the order of this court?
Yes, Your Lordship.
After the order of this court?
After the order of
this. This is when this order? This
order was come on 3rd 10 2023.
And order of the court was?
Order of the court was
My Lord has passed the order on 12/4/2023 to comply the order.
See, this thing, this 35, to adhere to what OM 14.620, where's the 14.623? What OM is this? You bring it, Mr. Abraham, what's this? It's here 14.11, 14.6, where's the 14.623 OM?
14.6, I have not.
We have it with you, Mr. Khan. You have seen this letter, correct?
My Lord.
Then again, page 37. These are the.
Forget about that. See, if this first one, Department OM so on reservation roster. Prepare reservation roster.
Yes.
Right, MPC to conduct the examination. He said special interview.
Yes. Yes, special interview.
Then
this has been communicated by the personal department to.
Have you filed a fresh petition on this?
My Lord, I have filed. My Lord, one petition is pending. My Lord, that is they have floated a new advertisement. My Lord has already.
No. Regarding this, regarding this last order, 23 orders are complied with, and then what OM is this, Mr. Abraham? We bring it on next date. You produce it.
Your Lordship, then, if I'm pleased to take your Lordship to next, that is page 37. 37. They prepared the roster, Your Lord. We have prepared.
Who prepared?
This is by personal and administrative reform.
My Lord,
so there are 12 vacancies.
12 vacancies for the Garos and 12 vacancies for the Khasi.
Then why no special interview not done?
Because that roster, because other this Khasi and Jadda occupying, Your Lordship. So
This is not the case, my Lord. Vacancies are there, my Lord. Clear vacancies are there, my Lord. They just need to hold the personal interview, my Lord. They are not.
The special interview was what? To facilitate their proper organization, that's all.
Yes.
Because they've been working for a long time. This matter has been thrashed around the court for many years.
One of the petitioners,
Correct. That is one of the conditions. So the thing is that special interview, as has been done in your matter organization, which you've done for the other people who are grade 4 and grade 3, as per who were appointed prior to 2007. The same consideration was allowed by this court. And it's not a question of going again into, they're working in sanction post, correct?
Yes.
Yes or no? Then
post line. That's what we are from the.
That's what you helpless.
Because it is not within my power to conduct a special interview, Your Lordship. It has to be done by the personal department and the MPSC. From the department, we want them to have have a special interview for them. But it is not within my jurisdiction.
Personal department, with the approval of the personal department, only all the interviews were held.
Personal department is not met as a party, as a party in this case.
It is not required, my Lord, to make each and everybody party.
No, that see, the thing is that in a contempt matter, now this is not complied with, we'll initiate contempt proceedings. You know, contempt matter is in two parts. One is bring notice of the court as a violation. Court examines. If there's a violation, then we institute contempt proceedings. Now, once contempt proceedings are instituted, it calls for a fresh show cause also. But then it comes under the High Court rules, right? Then to be held liable for contempt. Different. Now, even if we drop proceedings, if he express helplessness due to this, that means they are not party also. Then what are we
in that event, I can make the personal department also.
Yeah, implead them also.
Obviously.
Yes, Mr. H. Abraham submitted that the correspondents herein who have been arraigned as contemners are helpless to move the matter forward in view of the fact that the personal department has which is that? By the that page 35?
Page 35 is order data. The communication.
Communication dated
3/10/2023.
1 second.
3/10/2023. Page 35.
By communication dated. What is that? 3/10.
3/10/2023. Yes, which was received by us on 4/10/2023.
By communication dated 3/10/2023 under the hand of under signature of the Deputy Secretary to the Government of Meghalaya Personnel and Administrative Reforms (B Department) has raised certain issues with regard to reservation roster. It is noted that the observations run contrary to the directions of this court with regard to the holding of special interview. Next, at this juncture, Mr. Ensign please that meet out to implead the necessary respondents to be added from the personal and AR department. They is allowed this up to 2 weeks. Let them come.
Obliged. Till 70, my lord, connected. Till 70.
74.
Lordship, in item 69 and 70 are correspondent to.
That's a different matter, but not connected. Not
Same matter. Obliged.
74.
May it please your lordship. This is regarding the, my lord, pay revision matter, my lord. Before I start my argument, my lord, the state respondent, my lord, they have not denied the arrears amount of the pay revision, my lord, from 1/1/2027 to 19, my lord. They have not denied, my lord. Their affidavit, my lord, kindly see the affidavit, my lord. What is called for, my lord, is the since they have stated in the affidavit, the request from the MTC to the department, Commissioner Secretary to the government, my lord, is still pending, my lord, and a special package yet to release, and there is a likelihood of release of the special package. So let the decision they can take a decision.
It's not incumbent upon them to accept. They're a autonomous body. Then,
yes, my lord. My lord, which is, my lord, they have in their affidavit.
Where? State number 1.
Yes, respondent number 1, my lord. Yes, my lord.
Which page?
My lord, yes, my lord. Page, my lord, 7, my lord. Para 7, my lord. My lord, may I read, my lord? Para 7. The last line, my lord. However, no assurance was given by the management of MTC in the last 2 years, as there is likelihood of the financial package to address the issue raised by the petitioners. In 156th meeting of the Board of Directors of the Meghalaya Transport Corporation held on so-and-so 2024, and during the discussion on the review of the action taken on the decision of the 155th meeting held on 18 November 2021, the chairman apprised the members that the workers' union had made him relating to the implementation of the 5th Meghalaya Pay Revision 2017 with effect from 1/1/2017 and payment of arrears thereof. However, till date, the matter is still pending for consideration with the government. The director of the MTC has also written, my lord, to the department for release of the arrears amount. With regard to the...
Not arrears, is a question of...
My lord, revision of pay, my lord.
From which date is to be adopted?
Yes, my lord. Yes, my lord.
Yes, government, what?
At least they can take a decision on that, whether, my lord, whether funds will be released or not, my lord.
There is no, we have already stated there is no fund, your lordship, because the amount and financial implication is very high, which is why the board has taken a decision that it would be implemented from 2019, and that has already been released. Now from 2017 and 18 they are claiming that, your lordship. But on 2 occasions the board has
have
met.
No vested right because
no, they don't have, your lordship, because they are not at par with the government employees.
My lord, financial crunch or financial hardship cannot be the ground.
No, but you are not at par with the government.
It's not a question. See, what does the court mean saying vested right? If you have a vested right,
yes, my lord.
Suppose a question of payment of gratuity, which is your right,
yes, my lord,
or pension, which is not a bounty,
my lord, yes,
then financial crunch is not an excuse.
Yes, my lord.
But in a case where it's an autonomous body,
yes,
where it's not that once a pay, commission recommendations are accepted, doesn't mean that they have to accept it in toto from the date the state accepts it.
My lord,
you understand? They have to look at their own requirements, and then sometimes they give you the benefit as done in earlier years. Suppose it says from 1990 they'll accept it, fine. But in this year what's happened is that they have not considered that, they have said that okay, fine, 2019.
My lord, as per the previous, my lord, the record of the MTCs and other, my lord, look at
yes, they from the date of the state's adoption. But in this case,
even in case of
show me the law that says that you can compel them.
We are bound to do it,
my
your
lord,
lordship.
in case of municipalities also, the funds, the state has released the funds. Exactly in case of MTCs also, my lord.
Mr. Hassan, what is your right to compel them? Can the court direct issue a mandamus that they have to accept the recommendations of the pay commission and implement it from the date the state? No.
My lord, the recommendation, my lord, the state has accepted that recommendation.
You can't maintain argument.
My lord,
You're not an employee of the state government.
my
You
lord,
have not
but
been
still,
appointed by the state.
my lord, the state has the responsibility, my lord, to.
It might be an arm of the state government, correct?
Yes, my lord. Yes.
Or maybe a PSU
It's a
created under
separate
state
entity
government,
altogether.
or state government undertaking. But doesn't mean that you're employees of the state government.
Well, we are not the employee of the state government. We are the PSU, like MTC, my lord. MTC is an corporation, my lord. But still, the state cannot just wash away their
Of course, they can wash
rights,
away their
my lord.
hands.
My lord, it's their responsibility to maintain, my lord, because the pay revision comes once in a decade, my lord. My lord, kindly, my lord, consider this aspect once in a decade. And
Show me the law.
My lord.
Show me the law or take the order.
My lord.
That's all.
My
Show
lord.
me the law. Show me the law or take the order.
I'll
put it in your pocket also. Show the petitioner. Show me the law that you have an enforceable right to make the autonomous body, accept the recommendations of the state, of the pay commission, but yet the state accepted it.
My lord,
Show me the law.
I'll seek some more time, my lord.
Otherwise,
yes, my lord.
There's no merit here.
Yes, my lord.
Yes, Mr. S. Hassan, please develop some more time to prepare the matter. Yes, the 2 weeks. Yes. Otherwise, we can't issue mandamus. The hands are tied.
Yes, 79. I'll try to find it. Yes. I'll oblige.
79. 79 kakas there.
Short matter regarding pension. The grievance primarily is that there is a purported resignation letter given by the deceased husband of the petitioner, and according to them, according to the state lordship, they have acted upon the resignation, and as such no pensionary benefits could have been granted. But it has been the case of the petitioner right from the third round of litigation, this being the third round of litigation, that what she is essentially praying, lordship, is a comparison or a forensic examination of the signature. She says that it is not the signature of the husband, and she has placed certain signatures.
Gone for forensics?
It has not gone, lordship. And now also it has been denied on a very cryptic basis, if I may so submit. Kindly see page 55, annexure 13. This is the impugn order, lordship.
After his death.
Lordship may kindly see page annexure 13 at page 55, the third paragraph, lordship. Second, in her statement, she claimed that late so and so died in the year 2018 due to illness, but he had not received any financial benefits till his death. However, it can be seen from the records that Sri so and so has tendered his resignation on 20/12/93, and subsequently his resignation was accepted by the commandant by this office BO number so and so dated 5/2/1994. GPF was paid to late so and so on 16/6/94. In view of the facts, it is my considered view that the claim for pension by the wife of late so and so is without any merit. So, lordship, but the grievance, lordship, primarily the grievance, it had detailed representations were filed along with some certain specimen signatures.
Now, how can you overcome this hurdle?
Lordship, what I am only
praying,
is, lordship, if the state respondents are considered enough, kindly see page 39. What was my representation, lordship? Page 39.
They say this dispute exists in the representation.
Lordship,
6/2/24.
No, yes, that was done.
You filed a proper one.
I filed a second one again, bringing all the.
Where is that?
Lordship may kindly have
page 39.
No, that's the second representation which I have filed, lordship, is at page 43 onwards.
Okay, you file a fresh representation, yes.
Fresh, and here also I have taken reference of the previous one. Lordship may kindly refer to page 53, the last part of the representation.
Yes.
53, lordship, point number 1. Direct for verification of the alleged resignation letter through an FSL or such other forensic.
GPF has been released.
To recalculate the GPF. So I am only saying, lordship, that it was not my husband's signature, and they should verify it, because.
How can someone make someone resign? That is.
And I have also, because certain issues had occurred. He was beaten up at one point in the office and all. So be that as it may, lordship, the only grievance which rests is that, lordship, 17 years of service was given by the petitioner's husband, And
where's the resignation letter?
Lordship, that resignation letter is there.
At page 27, Your Lordship, annexure 3
27.
of the writ petition. And the typed copy is at page 28, Your Lordship. He filed.
See that, sir, I've read everything, got this read myself, but I don't have such stamina to render any more service.
Then that was filed on 20th December
First resignation
1990.
I saw because don't have any stamina to continue.
Lordship, in fact, what had happened, of course, this is, I don't have any such substantiative proof, but that some indication is there in the representations. What had happened is, Lordship, the petitioner's husband was beaten up in his job because of certain issues. And then he took leave to get his treatment. In the meantime, this resignation happened, Lordship.
93.
And he was.
The resignation was accepted on 5/2/94 after 41 days of the submission of the resignation, Your Lordship. Now the wife has come up to 26 years saying that that signature is fraud.
Lordship.
And he died only in 2018.
Oh, then
Why didn't he protest earlier?
No, I appreciate I appreciate
the wife, in fact, Your Lordship, if Your Lordship sees the death certificate, you'll find that her name is also not mentioned there, which means that she was never in the picture all these years when the husband was alive. Only after his death she has come saying that this resignation...
No, we know these cases. No, she is on a fishing expedition.
Yes.
Lordship, it is not a case of
fishing. If
after
something
20
bites.
He could have raised this issue, Your
See, the
Lordship,
thing is that
during his lifetime.
if he didn't resign,
He took the
in
GPF
93,
also.
it's accepted in 94, sometime maybe 2 months or something after that.
2 months.
So why didn't she withdraw resignation?
No, that is what, Lordship, I appreciate that there are some lapses on the part of the petitioner.
There's lapses.
Because
Take
only
down
prayer,
his,
Lordship, was that if they can reconsider the thing.
There's no
the petitioner,
way we can reconsider it.
by way of this third round litigation, has assailed the third round litigation with regard to the petitioner is before this court is a third round litigation praying for terminal benefits of her deceased husband. Stop. In the first round litigation, that is WPC number 169 of 2021, comma, this court, by order dated 26/3/2021, without going into the merits of the matter, had directed for the representation of the writ petitioner to be addressed. Stop. It appears that what was the reply to the petition? That's not a record. What was rejected after the first petition? Where is that rejection? Rejection.
Huh? The first rejection.
Yes, the said representation was, however, rejected by a speaking order.
It was rejected primarily on the ground of delay, Lordship.
Yes, by a speaking order. That's a speaking order. By a speaking order on 29/2021. Stop. The writ petitioner thereafter preferred the second writ petition, being WPC number 144 of 2024. And this court, by order dated 6/6/2024, permitted the writ petitioner to file a fresh proper representation before the concerned authorities. Stop.
The writ petition was withdrawn by them, Your Lordship.
Yes.
And disposed of.
Yes.
It was allowed to be
permitted. Yes, permitted. This representation also was then taken up for disposal, and by order dated 19/7/2024, the same came to be rejected, wherein And it is recorded in the said order that from the relevant records, it was seen that the deceased employee had tendered his resignation on 20/12/1993, and subsequently his resignation was accepted by the commandant on 5/2/1994, and also that the final GPF amount had since been released to deceased employee himself on 16/6/1994. Today, Mr. S. Deb, by the fresh writ petition, has submitted that the dismissal or the rejection or representation was not based on any cogent reasoning, in as much as the stand of the writ petitioner is that her husband never tendered his resignation in 1993, and that the signature which appears in the said resignation letter is not his. He submits that the rejection of the representation has caused severe prejudice, in as much as her husband had rendered 17 years of service and should have been given his dues. Next paragraph. MST Yangi B. EAG with so and so has, in reply, has submitted that the writ petition, even the first, which was instituted in 2021, is hopelessly delayed. And in fact, the present petition does deserve any consideration. The senior counsel has submitted that if the resignation had not, if the resignation letter had not been signed by the deceased employee, he had ample opportunity at the time itself, even after being released from service, to seek relief by withdrawing resignation. She further submits that
It expired only on 17/9/2018.
yes,
Only on 17/9/2018, the deceased expired. So all this time he was quiet. Why was he quiet?
No, this is.
I'm sorry, Lordship.
Yes, the ombudsman. He had
ample opportunity.
It is also noted that the deceased employee had expired on 2018. Until his death, had not taken up this issue or raised any claim with the authorities, and that's only after his death in 2021 that the writ petitioner who claims to be his wife has come forward.
Of course, there's a submission.
Look, yes, that's a submission. This has come forward. He therefore submits on the ground delay alone. Writ petition liably dismissed. Next paragraph. On having heard the counsel of the parties and also examining the materials as placed, it is seen that the resignation, which is disputed by the writ petitioner as to its authenticity, was tendered on 20/12/1993, and the same was accepted on 5/2/1994. Stop. In this regard, the question of delay is vital vital in this case, as if the resignation was a contrived document, the deceased employee, as any normal person, so employer would have done, would have immediately taken measures to correct the same and to seek relief under the law. This was never done until his death on
17/9/2018.
17/9/2018. and as submitted by the learned senior counsel, is only in 2021 when the writ petitioner, who is stated to be the wife of the deceased employee, has come forward. Though this court has given reasonable opportunity to the writ petitioner, though this court has directed the respondents to address the representations of the writ petitioner, it appears that on the findings thereof and on the question of delay, no interference is called for by this court. Accordingly, for the reasons aforementioned, the petition devoid of merit and the same is dismissed.
Obliged.